that at the National Assembly, having been given 7 days, for the people to meaningfully participate in it. We look forward to a respectful answer of no. And for these reasons, we respectfully urge this Honorable Court to declare the Standing Order 64.2 and 64.6 as unconstitutional, null and void, to the extent they impose timelines whose purpose and effect is to undermine the articles that are mentioned, 10, 118, 1, 2, and 124 of the Constitution. I so respectfully submit. Thank you.
Thank you.
My Lord and my Lady, my name is Njomo John, appearing for the first petition with my colleagues, and I'll pick up from where my learned colleague Faith Waigo has left. I rise to briefly submit on the reliefs that the first petitioner is seeking before you. I know counsel who has submitted before me have mentioned variously part of what I'm submitting on, and that is the reason why I will not take long. My Lord, when this court delivered its ruling on the 31st of October last year, I want to refer to paragraph 158, being the background under which the first petitioner is before you. He's literally in court today. You know, there were worries as to what the court would do in the outcome of an impeachment and election or nomination of a deputy president in replacement of the former.
She is kind of a big deal. And no, it's not about her big office. Thanks to her big connection that keeps her big business always on. You too can be a big deal when you keep your business always on. Enjoy monthly payments, zero interruptions, predictable billing, and best-in-class coverage without daily recharges. Stay on always with Airtel Business Postpaid. Call 125 or email business.support@ug.airtel.com to sign up. Airtel, regulated by the Ghana Communications Commission.
Court in this matter, so that when we come before you, this court has an open page. All the reliefs that the petitioner is seeking are grantable by the court, because even Professor Githu Muigai, it's on record that he has given an undertaking that there will be full compliance. So that, Lord, the reliefs that the first petitioner is seeking are captured at paragraph 148 all through to paragraph 148 of the submissions. This is appearing at page 61 of the submissions by the first petitioner. Page 61. That is prayer number H. What are the appropriate reliefs? Starting from page paragraph 148, running all the way to paragraph 152. And the Honor, there has been various mentions of the issue of public participation. I want to address the prayer relief number 1, that is A declaration that the respondents have contravened the provisions of Article 10 and Article 118(1) of the Constitution by initiating a process leading to the removal of office by impeachment against the petitioner. My Lord, relevant to that particular prayer is the definition of what Parliament is at Article 93 of the Constitution. And this is what it says. There is established a Parliament of Kenya which shall consist of the National Assembly and the Senate. And very briefly, my Lord, we have been told there was some semblance of public participation conducted by the National Assembly. But on record, nothing has been demonstrated, or rather, the respondents, especially the Senate, has not given any indication that there was any semblance of public participation. The reason why I'm saying this is because Parliament is both the National Assembly and the Senate. Even if there was some public participation initiated by the National Assembly, there was none whatsoever that was initiated by the Senate. This is the reason why we are saying that there is violation of Article 118(1) of the Constitution, because the Constitution requires that Parliament shall conduct business in an open manner, and in its sitting and those of its committees shall be open to the public. It goes further to say that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. So that then the question is, what happens when the Senate conducts its business without involving public participation, without invoking public participation? The answer can only be that there is a clear violation of Article 118(1) of the Constitution, and we pray that then the court finds that in favor of the petitioner. My lords and my lady, we have gone to pray for a declaration under B. I don't have to read the whole of it, but it has been explained by counsel that some of the charges that were confirmed against the first petitioner, there was multiplicity and duplicity of charges. That you have allegations and particulars being referred to in support of a given allegation. So that then what we pray under a declaration that we are seeking under B, motion lacks the particularization and specificity required by Article 145(1) of the Constitution. This is important because it was submitted by Senior Counsel Ongoya, and he explained in detail how the charges 3, 4, and 5, particulars that were relied upon were in particulars or the charges in A and B, charge 1 and B, so that there were no particulars in support of those other allegations. The next prayer that the petitioner is seeking is as regards the inconsistent and violation of the Constitution under B, a declaration that the resolution passed on the 8th of October 2024 by the National Assembly to impeach the petitioner pursuant to the provisions of Article 145 and 150, and the communication dated 8th October 2024 sent by the Clerk of the National Assembly to the Senate titled that are both founded on a process that is inconsistent and in violation of the Constitution of Kenya. The reason why this prayer is being sought, my lords and my lady, is for the reason that there were many inadequacies resulting to the impeachment process, both at the National Assembly and the Senate. So that the culmination of it is that the process was a sham, and whatever that resulted from that particular process cannot sustain the impeachment process. So that we pray that the court can grant prayer number C as sought in the amended petition. My Lord, we also sought a declaration that for the purpose of impeachment of the President or Deputy President of the Republic of Kenya, adequate public participation must be undertaken in all the 290 electoral constituencies in Kenya, the diaspora constituency, and the 1,450 electoral wards where the presidential election takes place. My lords, the background on this is that the election of the Deputy President and the President takes place at the polling station. Counsel who has submitted before me have explained to my lords that the initial notice that was given was that public participation was to be undertaken at the county level. Subsequent communication was that there will be public participation at the constituency level, without an indication as to where the venue and more details to allow members of the public to meaningfully participate in public participation so that they can give their views. So that without a clear communication that public participation was to take place in all the 290 electoral constituencies and the 1,450 electoral wards, then that process cannot be said to have met the constitutional threshold on meaningful public participation. It is for that reason then that, my lords, we pray that you can find in favor of the first petitioner the declaration that is seeking under D. The subsequent declaration is on the timeline that was given, a declaration that the 12-week period provided under standing order 64.2 and 64.6 of the standing orders of the National Assembly is grossly insufficient. My lords, I will not repeat that because Council Faith Waigua has elaborated on the inadequacies and the prayer to have the same declared unconstitutional. Subsequent to that, my lord, we have prayer number F. Most of those others I'll consolidate. A declaration that the proceeding before the whole House plenary of the Senate of Kenya under Article 145 of the Constitution of Kenya are not limited to time-bound 10 days. This is, my lord, what Ochiel Dudley explained, that the 10 days that the Senate imposed on itself was not, did not have any legal basis, so that it was.
Your uncle wants you to get a loan. He says you should buy a Beamer to stop embarrassing him in front of his friends with your malnourished car. That you should buy one of those expensive shirts they call Versace, so that people stop spreading rumors that his family has no style. That you need an iPhone because he's tired of biting his tongue whenever he tries to pronounce that funny thing you're holding. Good thing you've got ABSA. Our loans are not designed for others to change what they say about you. They are designed to support your growth. Visit absa.co.ug for personal loans that help where it matters. ABSA, your story matters.
With the hearing before the Senate, the Senate proceeded, regardless of that particular communication, to proceed with the impeachment process. So that is a very clear indication that the process was not fair, and the right of His Excellency regarding GACHAGUA and Article 50 were violated to the fullest. My lord, declaration number H that you're seeking is that the National Assembly and the Senate, in their evaluation of the impeachment proceeding before them, failed to properly assess each of the specified ground and determine if they collectively and individually constituted gross violation of the Constitution. My lord, it has been explained to you again that even where a provision of the law has been declared unconstitutional, the National Assembly and the Senate still proceeded to find and uphold those particular allegations. The alikees have been explained, and the court has been taken through the process leading to the invalidation and declaration of the unconstitutional provision under that particular act. But nevertheless, the National Assembly did not consider it necessary to find that some of those allegations were even illegal, were unfounded, and could not stand the test of law. Next to that is an order that this court quashes several documents and communication. I will not read each and every order, but we have sought orders of certiorari to remove and quash the communication of 8th of October 2024, 17th of October 2024, resolving to remove the office of, from office by impeachment His Excellency Rigathi Gachagua as the Deputy President of the Republic of Kenya. The reason for this, my lord, is, as explained before, that there were legal illegalities that were committed along the way, and these particular notices of 8th of October and 17th of October were the culmination of those particular illegal proceedings, so that the only justifiable cause that the court can give is to quash the notices of 8th of October and 17th of October 2024, respectively. Subsequent to that, there is also a request or a prayer that the notice by the Senate of 17th of October be quashed. This is the notice communicating the impeachment of His Excellency Rigathi Gachagua to the National Assembly. My Lord, we have then all the other prayers that we have sought. And my Lord, by the time someone is being elected to the office of the Deputy President or any other office, the expectations that come with it. We have given an authority that this court can award damages where there are violations of the Constitution. This is the case of Imanyara versus Republic, where the court held that where there are violations of the Constitution, and this is at paragraph 151 of our submissions, my Lord, you'll have a chance to look at it. The case of Imanyara and two others versus the AG, 2016 E-Kenya law reports, that where the court said that award of damages for constitutional violation of an individual's right by state or government are released under public law remedies within the discretion of the court. So that at paragraph O of our prayers, the first petitioner has come before you and is praying for general damages, punitive and aggravated damages. These are not far-fetched because the court has previously found that they are awardable by the court, because if we have demonstrated to the court that his rights were violated, then the court can award damages as prayed under paragraph 01 of our submissions. My Lord, we have also explained in detail that he was earning a salary that maybe I don't have to give a figure because there's a lot of calculations, mathematical calculations, but you'll have a look at paragraph O, where we have listed the benefits that the Deputy President was earning, what he was entitled to, and what his salary could have been if he worked for the 5 years that the Kenyan people had given him a mandate. So that we have therefore calculated those particular salary expectations and benefits that he was entitled to under the law. And we pray that the court can allow and award those particular prayers as sought. My Lord, the office of the Deputy President attracts some benefits, again, other than the salaries, which we have enumerated under paragraph P, because there are quite a number, including quite a number of issues, cleaners, gardeners, and all that. I believe that my Lords will have a chance to look at those particular prayers and the allowances that he could have been entitled to, could he have served his full 5-year term. We do have the play that the court will allow the prayers as sought, and I believe you'll have a chance to have a look at all of them in detail, one by one, in awarding and agreeing to allow the petition as prayed. I think, Mr. Mashari, you have a word to mention about it.
I just wanted to remind my colleague that he needed to emphasize that most fundamental matter called costs. We need costs on behalf of the Deputy President for all these bad things that have been done to him and to us. Thank you very much, my lords.
Well, that concludes the highlighting on behalf of the first petitioner. We thank you.
Thank you. I see Dr. Gada standing up.
Yes, Your Lordship.
You said you wanted 2 hours, huh?
Not 2 hours. We will be done in an hour or less. Myself and my brother Sakim.
Who else is here to speak?
My Lord, for the third petitioner.
I'm also present on behalf of the second petitioner. So I don't know if I will be able to address today or the other day. Oh, my name is Teresia Wanjiru Kimoto of Tess Kimoto and Company Advocates Kerugoya.
Yes, my lords, if I may, just for a minute.
Yes.
I'm not objecting to Tess. My lord, in terms of equality of arms, I am concerned that the petitioners, having had 5 hours, and the other parties having the possibility of attacking another 1 hour.
When you gotta go, go for Neptune, the softer 2-ply tissue paper, available in plain white and colored.
Why me 20?
Well, I think my learned friend, Professor Tom Ojienda, is being anticipatory. Let him wait and see perhaps how long we take. Then he can say at that time how much time he wants, rather than trying to, put the court in some straitjacket. We are very grateful, those appearing for the first respondent, but I do plead that the other counsel appearing for the other petitioners have their day in court.
We are in court.
Yes.
We are in court. They are having their day.
They have their day.
Yes.
They have their day in court.
Yes.
Because what this honorable court will ultimately say, either way, is going to apply in future.
I think the only issue we need to address is how much time do we give them? And I think we should appreciate that we don't have all the time. So let us plan to share maximum of 1.5 hours.
Your Lordship, I'm sorry, but I'm constrained to object to that approach. When we had the hearing for the conservatory orders, we restrained ourselves and took our and allowed the court to limit our time. But I think for the petition, let us have sufficient time to ventilate on all the issues. We shall take the least amount of time possible. But if you say 1 hour and a half, and Dr. Ogada is coming up, I do not know how much time you will have to for the rest of us.
I think we are wasting time. Let's proceed. We'll see how far we'll go.
Good afternoon, Your Lordship, Your Ladyship. I appear alongside my brother, Mr. Sakimpa. We appear on behalf of the 4th to the 8th petitioners. Ab initio, we will be relying on the following documents. We will be relying on the petition dated 18th October 2024, the affidavits in support sworn on 18th October, the written submissions dated 16th January 2026, the list and bundle of authorities dated 16th January 2026, the further list of authorities that dated 25th April 2026. All power has a limit. All power has a limit. Certain values in the Constitution have been designated as foundational to our democracy. This in turn means that as pillar stones of this democracy, they must be observed scrupulously. If these values are not observed and their precepts are not carried out conscientiously, we have a recipe for constitutional crisis of great magnitude. In a state predicated on a desire to maintain the rule of law, it is imperative that one and all should be driven by a moral obligation to ensure the continued survival of our democracy. That is a paragraph from Nyathi versus member of the Executive Council for the Department of Health, Gauteng, and another 2008, Madala J at paragraph 80. it's in our list of authorities supplied, dated 25th of April 2026. My good friend, Elisha Ongoya, wandered in the morning, and I joined him in the wandering. Which way, Kenya? What is the state of our morality in terms of our constitution? We have provided a case, and that case will form my next line of submission, the case of EFF, Economic Freedom Fighters versus National Assembly, 2018 South African Constitutional Court. Which way for Kenya? The first petitioner has gone through what happened in terms of the process. It paints to us a very worrying state in terms of the health of the democracy that we have in this country called Kenya. This is a clawback in terms of the Constitution and the state of our democracy, culminating into the Constitution 2010 that was characterized by huge cost for the ordinary Kenyans. People shed blood, people were killed, and people died. We should not lose focus of that. And that state of affairs painted by the first petitioner leads me to pose this question to the court. Did we need specialized rules and procedures for this process of investigations and hearings to be established before the process commenced? Did we need specialized rules and procedures before the process of impeachment investigations and hearings commenced? That is a question, your lordships, your ladyship, this court must answer. And like my elder senior counsel, Elisha Ongoya, I'm relishing to read the answer to that question from this court. On our part, we respond in the affirmative. Yes, we must, and we needed to have specialized rules before the impeachment began, either in form of a specialized code or it ought to have been mutually agreed between the parties. Parliament ought to have sat down with the Deputy President and agreed on the rules of procedure, or else we should have had a specialized code. For the following reasons. Number one, protection of constitutionalism and the rule of law. Pre-established rules ensure the impeachment follows constitutional norms rather than political convenience or sudden improvisation. The Speaker extends it to Saturday. Parliament says no. We will do as we wish. Error. Kosa kubwa. Secondly, prevents abuse of power and political witch hunts. Clear procedures make it harder to weaponize impeachment and partisan revenge for short-term political gain. Number three, guarantees of fairness and due process. The office holder facing impeachment deserves predictable procedures, notice of charges, a right to respond, and an impartial hearing. Number four, enhances legitimacy and public confidence. When procedures exist beforehand, the public is more likely to trust the outcome as lawful and not pre-engineered. Public trust, public confidence. Next, it ensures
Did you know it takes minutes to become a Darif affiliate? First, sign up on darif.com/partners. Next, confirm your email. After that, fill in your information. Lastly, get approved and access your unique link. Everything you need to promote Darif is ready for you. Sign up today and grow as a DARIF partner.
Serious constitutional interrogation such as an impeachment in that manner. No, we say. Promotes separation of powers. Structured procedures reduce institutional conflict by clarifying the roles of parliament, courts, and other bodies. Number 7, provides clarity and efficiency. Investigations and hearings move faster, are more coherent when procedural uncertainty is removed. Number 8, protects minority and dissenting voices. Those that dissent, and for aught we know, perhaps we had dissenters, people who are willing to vote against the impeachment. We may never know because the rules lacked. Formal rules ensure minority members in legislative bodies can participate meaningfully and are not outshot by majorities. It creates objective evidentiary standards. We had objective evidentiary standards from the courts. If that was applied in Parliament, that we don't know. But if that was agreed to in terms of rules, we will know what we are facing in terms of what evidentiary standard are we going to abide with. Finally, it builds a stable constitutional precedent. A predictable framework helps future impeachment processes remain consistent, credible, and less destabilizing to governance. A stable constitutional precedent can only emerge where constitutional values are treated as binding rules rather than aspirational rhetoric. If foundational values of the Constitution are understood as enforceable obligations, they naturally demand structured, predictable procedures whenever the most serious constitutional powers, such as impeachment, are exercised. In this way, fidelity to constitutional values become the anchor for consistency, ensuring that future impeachment processes are guided by principle instead of political expediency, and that governance remains stable, credible, and firmly rooted in the rule of law. The reasons for a rule-based impeachment process. There are no rules. In terms of the constitutional values at play, this court is going to make a decision for expediency. This is not just any other decision. Constitutional values are not decorative. They are not mere suggestions on the walls. They are binding obligations. These are our pillar stones, and these values that we have in the Constitution, such as the rule of law, due process, constitutionalism, accountability, transparency, separation of powers, are a must. They are inextricable. So when impeachment procedures occur without procedural law, clear procedural law, Parliament is no longer implementing the Constitution. It is operating outside it. And I dare confidently, with all the strength from my ancestors from Nyahera and Kisumu, say this, that impeachment is not a political ritual. It is a constitutional trial. May I repeat this for members of the National Assembly? My senator from Kisumu is here. Impeachment is not a political ritual. It is a constitutional trial. So without procedure, the process becomes arbitrary, and this directly undermines constitutional supremacy. That is one. Number two, the rule of law requires procedure. Power cannot operate in a vacuum. The rule of law means that power must be exercised through known, predictable, and fair procedures. We are extending time for you till Saturday. No, we are continuing with the impeachment immediately, irrespective of whether you're present or not. That is rule by man, not rule of law. Failure to have procedural law in the context of this impeachment meant this, that we did not have clear, predictable rules of evidence. That is one. The burden of proof, if at all it existed, kept on being a moving target. There was no right of defense. It was never guaranteed in the first place. People wanted to finish with what they wanted to do and move on. There are no clarity in terms of timelines, fairness, or impartiality. This creates a dangerous precedent where decisions depend on political discretion, not law. The process becomes rule by numbers, not rule of law. And in constitutional theory, absence of procedure means absence of legality. May I repeat that? Absence of procedure means absence of legality. Number 3, impeachment is a quasi-judicial process, not a political vote. That term quasi-judicial has been used a lot here. But what is exactly meant by quasi-judicial? In my other life, I'm a member of the academy, and I see two senior members of the academy here. They can confirm that, and may God bless them in advance. Professor Jenda, Professor Gido Muigai, senior members of the academy. Quasi-judicial power means this, that this is the power to determine disputes or making findings affecting the rights of individuals, similar to the way courts operate. What was at stake during the impeachment? A validly elected deputy president of the republic was going to be impeached. His rights personally and the rights of his many supporters, those who voted for him as part of a ticket, were going to be affected. The consequences are there in terms of the quasi-judicial power. The removal of a deputy president being a very serious constitutional action. It has consequences for the electoral will of millions of voters, stability of the executive, continuity of government. And because of this gravity, impeachment must meet quasi-judicial standards. Quasi-judicial standards, these are the principles of good governance. I don't want to go through the whole list, but again, members of the academy, Professor Don Oliver has reduced the principles of good governance into 4. Very quickly, these are legality, procedural propriety, rationality, and proportionality. The Oliverian quadrant: legality, procedural propriety, rationality, proportionality. When this court retires, we pray that you are going to consider those 4 principles. This process, as has been brought out by the first petitioner, do they meet? Again, Professor Jenda should be familiar with Wednesbury degree rationality. That's a test.
Counsel, address the court, not the academy.
Most obliged. Most obliged. Most obliged. If I veer into the academy, please forgive me. Most of the time, I veer towards the academy. Wednesbury rationality. Has the Wednesbury rationality test been met in terms of this particular impeachment process? Proportionality. Look at the allegation on, for example, what was said and what ought to have been referred to the NCIC, the National Cohesion Committee. Was that proportional? Does it meet the proportionality test? And on that very issue, Senior Counsel Paul Bwino submitted to it. There's the principle of subsidiarity that is captured under Section 15 and Section 26 of the NCIC Act. Parliament ought to have deferred to the authority of the NCIC on the allegations made against the Deputy President. NCIC ought to have made the primary decision on the gravity or lack thereof of what was said. So the assumption of Parliament without going to the NCIC is not only illegal and unconstitutional, it also offends the principle of subsidiarity. When Parliament conducted itself in the manner it conducted itself, Parliament acted as the Hobbesian Leviathan. It became the investigator, the prosecutor, the judge, and the jury. This violates Article 47, principles of fair administrative action, and judicial action, quasi-judicial action. Procedural fairness protects the people, not just the office holder. Impeachment is often framed as an accountability of one individual, but constitutionally, impeachment protects the voters who elected that office holder. If procedure is absent or conducted in the manner it was conducted in this case, the electorate's choice can be overturned by unregulated political processes. This weakens popular sovereignty, a core constitutional value. Thus, the real victim of procedural failure is democracy itself. Whereas it protects, there are protections for the individual, the real protected target is the core principle of popular sovereignty. 5, the absence of procedure invites a constitutional crisis. Why? Because without procedure, courts are forced to intervene, parliaments claim political privilege, the executive legitimacy becomes contested. We have a deputy president who did not come through the ballot. That's a legitimate question. Institutional conflict arises between the arms of government. And this leads to the usual talk, judicialization of politics, politicization of constitutional processes, public loss in institutions. A constitutional democracy cannot survive when removal of national executive and office holders lack legitimate legal guardrails. 6, separation of powers demands legal boundaries. Parliament has the power to impeach, but not without limits. Parliament becomes a judge in its own course without procedural law. Checks and balances collapse. Majority power replaces constitutional restraint. Remember, we are a state under constitutional restraint, not abundant political power. The way in which this impeachment process was conducted contradicts the idea that constitutional supremacy restrains political majority. That is something we will invite you to find. The rules of natural justice, there are 3. The right to be heard, freedom from bias, and those have been submitted to. Then there's the 3rd rule, the rule in R versus Sussex, Justices Ex parte McCarthy, 1924. And this rule, as articulated by Lord Justice Hewitt, simply says this, that justice must not only be done, but manifestly and undoubtedly it must be done. Justice must not only be done, but manifestly and undoubtedly it must be seen to be done. In terms of this process of impeachment, the processes continued when the substantive subject of impeachment was in hospital. He did not have the opportunity to rebut or to respond to the charges. In terms of the 3rd rule, the first 2 were submitted to. I focus on the 3rd rule. R versus Sussex Justice Magistrates. Justice must not only be done, but must be seen to be done. Do we see justice to have been done in this context when somebody was sick in hospital and processes continue without him being present? It's a problem. Precedent danger. Today's deputy president, tomorrow's democracy. If impeachment can continue and happen in such a shambolic manner that it happened, future removals will be done and can be done more easily. The threshold for removing elected leaders becomes political convenience. My brother Ochiel gave us the history. I don't want to go through it. Political convenience brought us to where we are in terms of shielding the office of deputy president. Executive stability becomes fragile. This transforms impeachment from a constitutional safeguard into a political weapon. Is that what we want in terms of this court? In terms of the jurisdiction of this court, I have completed with the rules of procedure. I want to go to the jurisdiction of this court. The High Court has 4 jurisdictional capacities under Article 165. The High Court has original jurisdiction, appellate jurisdiction, supervisory jurisdiction, and writ jurisdiction under Article 165. At play, particularly with regards to the matters before this Honorable Court, are the supervisory jurisdiction and the writ jurisdiction of this court. The supervisory jurisdiction becomes particularly important under Article 165(6) when supervising quasi-jurisdictional capacity of various arms of government. And this is where the court will invoke its judicial review power or judicial review authority. What is judicial review? Judicial review has 2 limbs to it. Judicial review is the primary judicial function to preserve legal order by confining the political branches to their proper limits of power under the Constitution. That's the first limb. The second limb is protection of private individuals by preserving or preventing illegal encroachment on the rights of these individuals. Those are the 2 capacities of judicial review. And when the High Court, under Article 165 of this Constitution, stands as the primary guardian and interpreter of the Constitution and its values, the court exercises broad authoritative jurisdiction, including supervisory and constitutional.
Are you looking for a dream house? Or do you want to buy, sell, or rent property? Well, we can help. We can help you save money and time. All you have to do is visit www.20fast.re.
And supervisory jurisdiction is a capacity granted by the Constitution, and it's not an intrusion into the domain of the legislature, and is a necessary feature of constitutional design. I hear telepathically, and I can almost predict that you will hear this from the respondents, that Parliament has its right to formulate its own procedures. If the courts will be inclined to find it that way, we have provided to you a case, Maneka Gandhi versus Union of India, 1978. And it presents to this court a test. The Supreme Court of India, interpreting Article 21 of the Indian Constitution, speaks of due process in this manner. It says, number 1, that procedure as a capacity of due process must be established by valid law. That is condition precedent. That condition adds on to say that even if the procedure is prescribed by law, it should be fair, just, and reasonable. Fair, just, and reasonable. So when you retire to write your judgment and you're satisfied that there was a modicum of procedure, you will have to look at that procedure in terms of the Maneka test. Was that procedure fair? Was it just? Was it reasonable? Was it reasonable to continue with the process when somebody is at the current hospital getting treatment? That is a question you will have to answer. In conclusion, a determination of impeachment is not a routine judicial exercise. It lies at the crossroads of law, constitutional governance, and the stability of democracy itself. La santé de notre politique, as the French say, the stability of democracy itself. The court's voice in this moment is not confined to the litigants before it, but resonates to the nation and future generations. This is a modern moment. Your judgment will either confirm that constitutional authority is bound by the discipline of law, or suggest that the most serious constitutional processes may unfold without the safeguards of the Constitution as required. By carrying out this solemn responsibility, the court protects the supremacy of the Constitution, sustains public confidence in democratic institutions, and ensures that the exceptional power to remove a constitutional office holder is exercised strictly within the confines of the rule of law. Nunca más, never again, should we go to the dark old ages. I submit. My brother Sakimpa joins in next.
Thank you.
Yes, Your Lordships and my lady, my name is George Sakimpa. We do appear together with Mr. Ogada for the 4th to 8th petitions. Your Lordship, the petition that is before you is originally Kerugoya petition E015, and which has since been consolidated in these petitions. So, Your Lordship, I will only deal with 2 issues because I do not wish to regurgitate what my seniors have already said. So, Your Lordship, I will just handle 2 issues, the first one being on the element of public participation, and it is going to be in twofold. That is from at the impeachment level, and secondly, public participation in terms of the appointment of the Deputy President, Professor Kithure Kindiki. And the second issue, Your Lordship, is on the Senate and whether it was open for the Senate to apply the plenary route. So, Your Lordship, I will start with the first issue of public participation. Your Lordship, the principles of public participation have already been eloquently espoused here, especially the BAT Supreme Court case. So, Your Lordship, I will not delve into that, other than to add that there is an international association for public participation, which has since developed at least 7 core principles when it comes to public participation. Your Lordship, Kenya, under Article 2.5 of the Constitution, general principles of international law do form part of Kenyan law, and therefore we do rely on those provisions. And there are 7 principles, and basically they have been well captured in the Supreme Court case of BAT. So, Your Lordship, so I would not wish to mention the 7 of them, other than to be referring to them when it is necessary. So, Your Lordship, the most important element of this public participation is that it has to be qualitative and quantitative. So, Your Lordship, what I'm going to do in these short submissions is to go to the evidence and to actually demonstrate that the public participation exercise that was conducted on 4th and 5th of October 2024 were neither qualitative nor quantitative. So, Your Lordship, I will begin with the affidavit that was sworn by the 4th petitioner, that is Honorable David Munyi Madenge, where, Your Lordship, in that affidavit, he says that he had no opportunity at all to participate in terms of echoing the views. And what was the reason for his inability to air his views? Your Lordship, the reason is that when he went to the designated center, Your Lordship, that center was closed. First of all, Your Lordship, the center was not open. It was closed, and there are evidentiary documents that were attached to his affidavit to confirm that that venue was closed. And that is what he has deponed in his affidavit, to the effect that he did not participate at all, because all the residents of Kirinyaga in that instance who went to that particular station did not participate. They dispersed without having given their views in terms of the impeachment of the second deputy president. So, Your Lordship, the next issue is on the issue of the notice. Your Lordship, from the notice, especially the extension notice of public participation, that notice was pursuant to the orders that were issued by Honorable Justice Richard Mwongo in a petition that was earlier filed, and where the judge said that the modalities that were put by the National Assembly were not sufficient, and therefore ordered for a second phase of public participation. So, Your Lordship, what the National Assembly did, instead of going back and preparing for a proper public participation, as was ordered by the judge, they simply extended the public participation. Your Lordship, from the annexure that we filed, that is DMM1, Your Lordship, the notice is actually dated the same day when the extension was actually supposed to happen. So, from the daily newspapers that were filed, Your Lordship, it was on the very same.
Hello?
Uncle Mo?
Yes?
This is Absa. We have a new date for the Seven Hills Run. It is 17th May, and we have concluded you will be our MC, but on one condition. You must run.
Can I run like on Teams?
No.
No,
We're
I
looking
can't have two
forward.
masters. Do you have some glucose? 2 sacks.
Had given a percentage in terms of the qualitative aspect, that out of 50 million Kenyans, only 200,000 gave their views in respect to the impeachment of the second deputy president. So, Your Lordship, that translates to 0.04%. And that is what basically said it's still 0%. So, Your Lordship, it was not quantitative and it was not qualitative. And Your Lordship, I only want to mainly emphasize on the decision that we filed, Law Society of Kenya versus National Assembly, 2025, where, of course, the court, in agreeing with the BAT case, the court said that public participation must be real. It is not a cosmetic or a public relations act. It is not a mere formality to be undertaken as a matter of course just to fulfill a constitutional requirement. There is need for both quantitative and qualitative components in public participation. So, Your Lordship, I have already submitted that it was neither qualitative nor quantitative. So, Your Lordship, I want to go now to the next issue in terms of the public participation in respect to the appointment of Professor Kithure Kindiki as the Deputy President. So, Your Lordship, and I'll be referring to the memorandum that was signed by the President. And Your Lordship, we have it in page 1 of the affidavit that was sworn by Honorable David Madenge. It is page 1. So, and the document is a presidential memorandum of nomination by His Excellency the President William Ruto to the National Assembly. And it says that whereas pursuant to Article 150 of the Constitution, a vacancy has arisen in the office of the Deputy President. So, Your Lordship, in relation to that, our submission is that this nomination of Professor Kindiki was subject to the Public Appointments Parliamentary Approval Act, that is Cap 7F of the laws of Kenya. And Your Lordship, in respect to this particular act that I'm referring, the Presidential Memorandum of Nomination is substantially in compliance with the provision of this act, except on the element of public participation. That is where the National Assembly drew the line, that the memorandum of did comply substantially with the act, but they chose not to undertake public participation. And I will start with the objective of this act. So, and the act says it is an act of parliament to provide for procedures for parliamentary approval of constitutional and statutory appointments and for connected purposes. So, Your Lordship, from the memorandum by the President of nomination, it is clear that this is a constitutional appointment, because he actually says that pursuant to the provisions of Article 150, a vacancy has arisen in the office of the Deputy President. So, in essence, Your Lordship and my lady, this is a constitutional vacancy and a constitutional appointment that was subject to the provisions of the Public Appointments Parliamentary Approval Act. And Section 3 of that Act says that the exercise of powers of appointment. So an appointment under this Constitution, that is Section 3, an appointment under this Constitution or any other law for which approval of Parliament is required shall not be made unless the appointment is approved or deemed to have been approved by Parliament in accordance with this Act. So, Your Lordship, it is clear that the appointing authority in this case was the President. So after appointing Professor Kithure Kindiki as a nominee for the position of the Deputy President, it was subject to the application of this Act. And as I said, Your Lordship, the memo complied completely in all aspects with this Act, save for public participation. So, and Section 5 also provided for notification of nomination. And it says that an appointing authority shall, upon nominating a person for appointment to which this Act applies, shall notify the relevant House of Parliament. So it is through this Presidential Memorandum of Nomination that Parliament was notified of this appointment of Professor Kindiki. And it further says that a notification of appointment shall be accompanied by information concerning the nominee having regard to the issues mentioned under Section 7. So, Your Lordship, I am sure that you will have an opportunity when you retire to examine this presidential memorandum. And in fact, it does highlight that the President says that for reasons whereof I have enclosed the following documents, and which Senior Counsel Paul Mwite said that it was done in an ungodly speed. So, Your Lordship, I want to reiterate that the essence of this Act was provided by Parliament so that it provides safeguards, especially on the issue of public participation, where the citizens will be given an opportunity for them to give views on the new nominee. And that is the procedure even in terms of the appointment of cabinet secretaries and all the appointments that are made under the Constitution. And Section 6, which is the most important part, it says that the committee, Section 6(4), approval hearing. So the committee shall notify the public of the time and place for holding an approval hearing at least 7 days prior to the hearing. So, Your Lordship, 7 days prior to the date of the hearing. Your Lordship, of course, from what we've heard is that the impeachment was done on the 17th of October, and on the next day, that is when the President forwarded this memorandum of appointment. So, Your Lordship, from that moment, the law requires that before the approval was done, the public had to have been given a notice of at least 7 days. So, Your Lordship, and the President further says, in forwarding this nomination, that, and he quotes Article 149 of the Constitution, which says that within 14 days after a vacancy in the office of the President arises. So, Your Lordship, within 14 days, of course, this was done within a few hours. It was, the impeachment was done at night, and in the morning, the President did this act. So the President shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. So, Your Lordship, under Article 149, the Constitution gave...
Elevate your career with the London School of Business and Finance. We offer a global MBA with 5 specializations, a Master's in Finance and Investment, and a Master of Science Strategic Marketing. LSBF is a trusted institution with a 4.8
that have been given by the President forwarding the nominee. Parliament was under an obligation to consider those documents within a period of 60 days. Your Lordship, by midday on 18th of October, Parliament had already voted on the issue of appointment of Professor Kindiki in complete disregard of Section 6.4 that required the public was to be given at least 7 days so that they can give their issues in terms of the suitability of the Deputy President nominee. Your Lordship, but obviously that was not done. And Your Lordship, I'll also now refer to the response that the National Assembly, in their submissions, they have filed, or rather they have given a ridiculous response to these submissions that we made. And under paragraph 361 of their submissions, they say that, in fact, this was a sui generis, it was a sui generis procedure, to the effect that it was not an approval, but a vote by the National Assembly. Your Lordship, assuming even we take the argument that they say that in fact it was a vote and not an approval hearing, Your Lordship, then the provisions of Article 118 of the Constitution will then apply, because they will still need to conduct public participation as required under Article 118. And Article 118 provides that public access and participation. So it says that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. So, Your Lordship, even if they escape the provisions of Section 6.4 of this Act, of the Public Appointments Parliamentary Approval Act, then they cannot circumvent the provisions of Article 118, which requires that Parliament must still, in all its businesses, involve the people. And Your Lordship, there is an authority that I want to rely on, and that is Legal Advice Center and 2 others. It is in our case, in our bundle of authorities, versus the County Government of Mombasa and 4 others. It's a 2018 decision. And Your Lordship, I just want to quote in verbatim a very small part where the court said that the purpose of permitting public participation in the lawmaking process is to afford the public an opportunity to influence the decision of the lawmakers. So, Your Lordship, assuming that we were to take the proposal that they said that this was a vote that ought to have been taken by the National Assembly, then under Article 118, they must have sought public participation before they made the vote to approve the Deputy President nominee. And Your Lordship, they further give a fallacious explanation and say that actually it is equal to the election of the Speaker and Deputy Speaker and members of the regional Parliament, that is IALA. So, Your Lordship, that is not true. In this case, this nominee is directly appointed by the President, and there is a memorandum of presidential appointment. In the case of a Speaker and members of the East African Legislative Assembly, they are directly elected by Parliament, or rather in whichever house that is applicable. So there is no nomination that happens by any authority in terms of before the Speaker is elected. They are directly elected by the members of Parliament. So, Your Lordship, the last issue that I'm going to discuss as I conclude is on the issue of whether the Senate violated Article 145 in terms of taking the plenary route. Your Lordship, our submission is that it was not open in law for the Senate to take the approach of the plenary. And my learned senior Ochiel Dudley had already discussed Article 145.3. So, Your Lordship, I will not belabor on that point, other than to submit that under that provision, that is Article 145.3, where it says that the Speaker of the Senate shall convene a meeting of the Senate to hear the charges against the President, and the Senate by resolution may appoint a special committee comprising 11 of its members to investigate the matter. So, Your Lordship, even if we were to apply all the statutory, or rather all the interpretations, rules of interpretations of the Constitution, all of them will point to the position that the appropriate route was the special committee. And Your Lordship, there is, the first rule is the literal, of course, interpretation of this provision. It is clear that from the reading of that provision, there is nowhere in which the framers of the Constitution provided that a plenary session can be held to investigate into the conduct of the Deputy President. And in fact, Your Lordship, from Article 145, it is clear that the Constitution was very clear in terms of the impeachment of the President, because it does apply to the President, and of the Deputy President. It went further to actually provide what needs to happen. And it is a constitutional buffer that was put there to ensure that whoever is undergoing the process of impeachment will get the benefit of the law. And I will shortly be reading the provisions of Article 27 of the Constitution, where it actually provides for equal benefit of the law. And maybe I can just quickly, as I finalize, read section 27(1), which provides that every person is equal before the law and has the benefit and has the right to equal protection and equal benefit of the law. So, Your Lordship, under Article 27, there is a benefit that has been, under Article 145.3, there is a benefit that has been put there by the Constitution, and which the second Deputy President was entitled to benefit from this provision of the Constitution in terms of having a special committee to investigate into the allegations that were leveled against him. So, Your Lordship, and if we look at actually that provision again, if we were to take the position that actually a plenary is also a route that is provided here, it will actually amount to a discriminatory act in the following sense, my Lord and my Lady, that it means that the Senate will be deciding, there is no criteria as to when the special committee will be applied by the Senate and when a plenary will be applied by the Senate. And Your Lordship, what that means is that it will depend on whether the Senate actually, you are in good books either with the Senate or whoever who is in charge of those impeachment. Because there is no procedure that actually provides that under these circumstances, a special committee must be undertaken, and under these special circumstances, then the plenary can be undertaken. It is left to the Senate to determine at whichever time they are going to use whichever mode. And Your Lordship, that has been demonstrated even in the impeachment of governors, where you find that some governors are subjected to the plenary, others are subjected.
And one thing about derivative, yeah, when you just know what you're doing, all right, trust me, you're good to go, all right? Less manipulation, simple and straightforward. Apparently, I think we have like few female traders, like in where I'm coming from, in Nigeria to be specific, all right? So I want them to see this as a motivation, to see this and understand that it's very, very, very possible with derivative, to be specific.
Investigating, first of all, whether the charges have been substantiated before a recommendation is made to the Senate. And finally, the other rule that I want to rely on is on the Latin maxim that expressio unis est exclusio alteras. So, Your Lordship, that provision basically means that what has been expressly provided under the Constitution, any other thing is excluded. Your Lordship, the framers of the Constitution, if they wanted to have both modes available, then, Your Lordship, there was nothing difficult in them saying that either they investigate by the committee or by plenary. They expressly excluded the provision of a plenary, because what the Constitution wanted is a process where the president or the deputy president is given an opportunity to, first of all, for the Senate to first of all investigate by the committee, and finally that the matter be deliberated in the Senate. So, Your Lordship, in light of those brief submissions, we do pray that this Honorable Court finds that the impeachment of the second deputy president was unconstitutional, invalid, and null and void. Those are my humble submissions.
Can you in just 1 second tell me the remedies we're seeking in this petition?
Yes, Your Lordship. In our petition, we have several prayers that we've sought, and the first prayer is a declaration that the appointment of Professor Kithure Kindiki as the Deputy President of the Republic of Kenya was invalid, null and void for the reasons that we've given in terms of there was no public participation. Your Lordship, another prayer that we did seek is a declaration that the National Assembly and the Senate were under an obligation to undertake separate public participation in respect to the impeachment of the second deputy president. Further, Your Lordship, another prayer that we sought for a declaration that the public participation that was conducted by the National Assembly on 4th October and 5th of October was not proper, effective, and meaningful within the provisions of Article 10 and 118 of the Constitution. And finally, that the impeachment process of the first interested party, being the second deputy president, was invalid, null and void. Those are the submissions. And Your Lordship, of course, cost of this petition.
Thank you very much.
And we do support the position that was taken by the first petitioner. Most obliged, my Lord.
Thank you. Mr. Umoke.
Your Lordship, I would like to present my petition on a fresh day. So I'll let Ms. She can go ahead.
Are you revising the directions which we made without application?
No, Your Lordship. I would like she's for the second petition. She can proceed.
So why do you want a fresh day?
No, I can still carry on today.
Yes, my name is Teresia Wanjiru Kimoto Makazi from Tess Kimoto and Company Advocates Kerugoya. I'm for the second petitioner. So my petition is the one dated Okay, thank you. It's the one dated 25th September 2024. And in that petition, we are seeking several orders. And in those orders that we are seeking, one, we are seeking that the then Honorable Rigathi Gachagua, there be a declaration that the constitutional rights of the applicant, who is the petitioner, provided for under Article 10, 27, 28, 29, and 47 of the Constitution have been violated by the respondents. And that the first respondent, who by then was the current Deputy President, be ordered to issue an apology to the NIS members and staff due to the utterances and speech made on the 26th June 2024. Cost of the petition and any other relief the court may deem fit. Of course, we wish to say that our petition has not been opposed by anybody. Let me finish. And we rely, of course, on the facts in support of the petition and our supporting affidavit as it is. We also wish to say that the reason why we had done an application to stop the impeachment proceedings is because...
I don't like doing this. But clearly, Ms. Kimotho's petition is overtaken by events. The petition sought an apology by the second Deputy President to the NIS. That did not happen. The impeachment occurred. A vote was taken on that question, and it is the subject of the first petition argued by Senior Counsel Paul Mwite. So Ms. Kimotho should sit down. Thank you.
No. We are opposed to that because that's not true. The apology we were seeking is an apology from the Deputy President, whether he's sitting or not sitting. So we are very much in place. And again, we also wish as I proceed before I was interrupted by my senior, I wish to say that we are also in support of, we are against the process of impeachment. And we are going to say why, if I'm allowed to say. The reason why we are in support of, why we are against, the impeachment process is that the grounds that we relied on in our petition are the same grounds that were being litigated by the Senate. The judge, when we went to, our petition was first, E013. When we went to the High Court at Kerugoya, we raised these issues. The Senate had not yet started the process, the impeachment process. And so we felt that if we were hard fast, then this whole issue would have taken a different turn. Because the same issues being raised in the Senate, then we ought to have been hard fast. And that's what we have been raising from the application that we did, and even in this situation when we are arguing our petition. We again say that if you look at the entire process, any person who goes to court must be heard. That's an Article 50, fair hearing. Then if the same issues that are being raised here are raised there, then of course there's an issue. It shows the senator, because we served the Senate, and the speaker clearly acknowledged that there's a petition going on in Kerugoya, but they ignored. This can only show their minds. They had made up their minds. And that's why now we are in support of the petitioners against the entire impeachment process. And this point is very, very important. Again, if you look at when we were consolidated, there came the issues again that are being raised here. Public participation, which on our part, we are supporting. We are saying the public participation that was not done well. His Excellency Rigathi Gachagua, His Excellency the President of Kenya, William Ruto, are people who are voted by Kenyans as a duo, not individually. So now when His Excellency, one duo, one person, one part of that duo is subjected to impeachment without the same process that was used to bring them to power, then that issue violates the Constitution. And why are we saying this? If you look at how they were elected, polling stations were everywhere. Each constituency, each polling stations in the wards, people were allowed to vote. So now when it comes to public participation, in where now we want to remove one duo, why are Kenyans not being told, come, let's get your views on the removal of one duo that we elected? How can we be told we don't have a right to be here right now? We do have a right, because if Kenyans did not participate equally as they did participate during the elections campaigns, then the process, any public participation that is said was done here was a sham. The second issue, why we are in support of these petitioners. Again, you can see how, and these are allegations that are in public domain. In fact, in our petition, we are accusing the Attorney General of these issues. Everybody kept on saying the MPs were given 500,000. The senators were given 1 million. These are allegations in the public domain. Can we say this process was fair when people out there are claiming there is bribery? We have seen several talk shows, people continuing saying these issues. So we are objecting to that process that was done. The other point that we wish to say is, okay, again, that was repeated, but I can emphasize, on the day of the Senate, we see the then Deputy President, Rigathi Gachagua, falling sick. We have served, there's our order, standing there, the Speaker of the Senate acknowledging that yes, we've been served with an order. Then suddenly the Deputy President becomes sick. And then what happens? The Senate does not care. They give a few hours, a few days, and then say, we will proceed, whether he appears before us or not. We go back to Article 50, fair hearing. Fair hearing means, however that person is, he must be allowed to give us his side of story. Kenyans were waiting. Kenyans were watching the TV. They wanted to hear His Excellency Rigathi Gachagua tell us, we voted for him. We want to know what happened. What happened, yet we voted a duo. So this chance we were not given. What we saw was in Senate, people come in and the lawyers speak and other allegations, paperwork. So Kenyans would have expected to hear his side of story. So in that, we say he was not given a fair hearing, and therefore that impeachment process was not conducted the correct way. Yes, I think my points, those are my few points. They are very fiery, so I don't want to keep.
Of course they are.
Yeah, I don't want to spoil anything. That's all for me.
Thank you. They are fiery. Thank you very much.
Okay.
Yes, thank you.
My Lord, Tess forgot to say that Kirogwea is in Kirinyaga.
Oh, yes.
Correct.
Can we see how many people are yet to submit? How many?
My Lord, there's the third petitioner.
Mr. Kibe. Where is Mr. Kibe? Can I see how many are yet to submit? So we'll proceed until 6.
Did your Lordship give an indication of up to what time we will be sitting?
6. 6.
Today?
Yes. You want us to amend it?
No. I
Yes.
was just asking for clarity on up to what time today we will be sitting.
You know, these people, I don't know where the councils have arrived from, because when we were taking quorum, they were not this large. Some people have just appeared. Some of the councils have just appeared now, because you spoke about 8 people. 8 councils, yes. And then after that, we have had now, I see quite a number of councils are here. I don't know, maybe.
Probably a misunderstanding. The 8 council I stated
yes.
are the 8 council appearing for the first petition. There are many other petitioners, and these council are for those other petitioners.
Yes.
But looking at the number, it's a matter entirely in your Lordship's
So we can do up to 6. Then after that, we can make further directions.
Okay.
Yes.
Thank you, my Lord.
My Lord,
My Lord, just so that I may get some clarity, the 2 of us going, 6 o'clock, that's in 30 minutes. It would be better if we took a proposal to get directions from the court.
When you gotta go for Neptune, the softer 2-ply tissue paper, available in plain white and colored.
Your Lordship, once again, my name is Morara Omoke. I am the 43rd petitioner. I filed a petition on my own behalf, and I was deeply offended by the manner in which the impeachment process was being conducted. And therefore, in compliance with the Constitution, I came before this court to defend it. It was not about my political alignment at the time, but about the Constitution, and that's why I'm here today. My petition is E027 of 2024. I have a supporting affidavit sworn on 9th of October 2024.
E0.
Sorry?
E047.
E027 of 2024. On the same date I saw the affidavit, 7th of October 2024. I filed very brief submissions dated 1st of April 2026, in which I sought to address 2 issues, as I do not wish to repeat what the first petition has already submitted on, but I fully support the submissions presented by the counsels for the first petitioner. And I will proceed to make a few additions. On the issue of public participation, I personally attended the public participation exercise at Kiambu Social Hall. I'm a resident of Kiambu County, although I'm born in Kisii. I attended, and I can confirm that the form that was provided to the participants only summarized the allegations against His Excellency Rigathi Gachagua without provision of any particulars or any evidence in support. So I can confirm as a participant, and there is no response in opposition to my petition to challenge that position. There was no evidence in support of the various grounds of impeachment as presented to the public. Secondly, there were no attachments of His Excellency Rigathi Gachagua's response, which at the time had already been filed before the National Assembly. It was never provided to the participants. And as Aleron stated, the public was only being asked to give an opinion of yes or no, and only a very small provision at the bottom of the form to say any other thing. I also would like to indicate that the manner in which, rather the form, the language was only in English. And as you know, in this country, we have two official languages, English and Kiswahili. Earlier on in Swanya's submissions, he did talk about the BBI case. Actually, in that case, I prosecuted that point on providing different languages when it comes to public participation, especially on an issue that is so important as this impeachment. It was only done in English. There's no explanation why it was not done. They could have taken time, but because there was the hastiness with which this process was being carried out, of course, there was no attempt to provide for any other language. In my petition, I gave a background to the impeachment process, and I did find fault with the lack of partiality on the part of the Speaker of the National Assembly and the Deputy, and the remarks they made prior to the impeachment process. Starting with the Deputy Speaker, she did say, mimi mwenyewe nitampeleka nyumbani in a public rally. Around the same time, the Speaker for the National Assembly even quoted a verse from the Bible about getting rid of something that is considered to be inappropriate in reference to the Deputy President, even before the impeachment motion was presented before the National Assembly. And this, as we said, while they do not vote in an impeachment process, they preside. So it is extremely important that the two individuals who have the mandate of presiding over the impeachment process ought to act with impartiality.
Your uncle wants you to get a loan. He says you should buy a Beamer to stop embarrassing him in front of his friends with your malnourished car. That you should buy one of those expensive shirts they call verses, so that people stop spreading rumors that his family has no style. That you need an iPhone because he's tired of biting his tongue whenever he tries to pronounce that funny thing you're holding. Good thing you've got ABSA. Our loans are not designed for others to change what they say about you. They are designed to support your growth. Visit absa.co.ug for personal loans that help where it matters. ABSA, your story matters.
I believe it should be before. Without it before this court would mean that I'm not able to point out the specific date, but it should be before the court.
We had two.
The one for the National Assembly. I'm making reference to the one in the National Assembly. It's 5th of October, 2024. Sorry, Your Lordship, 8th of October 2024. In that particular Hansard at page 18, I picked the remarks that were made by the Member of Parliament for Suba South, Karoli Omondi. At page 24, I picked remarks that were made, I believe those were made by Honorable Catherine Omanyo. And also, I'll take the two of them. So they went ahead and introduced other issues. Also, I forgot to mention the Member of Parliament for Mavoko, Patrick Macau. Actually, that is at page 24. Then at page 42 and 43, you will find those of Catherine Omanyo. I will not go into what they said, but I would ask the court to look at some of the issues they said, which to me were personal issues they had with the Deputy President, or some long-held grudges, which they used as their reasons for endorsing the advancement of the impeachment to the Senate. This being an impeachment trial, which, as we said, in the standard set in the Wambora case, which requires a very high standard, and the Constitution, which also talks about grossness and seriousness of the misconduct and the violation. You cannot introduce any other ground, even if that's what is your reason. You have to debate, you have to vote on the impeachment on the basis of the grounds that have been stated in the motion. So that is another failure, which on that basis I would ask the court to find that the impeachment failed to meet the standard, the constitutional standard. It has to be the constitutional standard and threshold, and therefore it ought to be declared null and void. Your Lordship, I would now move to present on the issue of lack of legal mechanisms, or rather legislation, to operationalize Article 150, in this case, of course, which incorporates the other articles on impeachment. Again, on this issue, I did make a presentation in the BBI case on the lack of legislation. In that particular case, the issue was lack of legislation for collection of signatures. And that was an important issue in the BBI case. And the court agreed, and I would ask this court to make that finding, which is extremely important, that this kind of a process, being so important, must have legislation. And I would like to state why it is important. For instance, when you look at the provisions touching on the election of a president and a deputy president, it's very clearly provided on the judicial review available to any party who is dissatisfied with the process. It's elaborate. It has to be that you come before the court, you raise your issues, the court makes a decision. Thereafter, then whoever is elected is sworn into office. So the Constitution, in a way, has actually enforced some conservative relief. However, that is not provided on the issue of impeachment, and therefore, just as important as the process of occupation of that office, so should be the process of exiting that office. And that, therefore, would require legislation to address that issue. We were before this court, we argued on the issue of conservatory orders. Your Lordship, it leaves us in a difficult position if this court was to find that this impeachment process was unconstitutional. How do we cure the fact that His Excellency Rigathi Gachagua was hounded out of office, replaced, and now he's left without a solution? Because if we say, for instance, that if we were to order him back to the office, the kind of situation we face is difficult. And that is why it's important to have legislation to provide for room for judicial intervention before the swearing in of the new occupant of an office, if the court was to ever confirm the impeachment process. It also would also aid the person, the incoming, not to come in under the cloud of illegitimacy. Because as we are here today, issues have been raised by my colleagues about the fact that the replacement came into office hurriedly without any safeguards. You know, there was no vetting. Because being an appointee, then it reduced him to that level of requiring vetting. While for an elected deputy president, the vetting is with the people. They vet and they vote. So I would say that this is an issue that leaves us in a, which actually paints a cloud of doubt on the efficacy of fair hearing in the Constitution. And my hope is that the judiciary would acknowledge that the fact that we did not have conservatory orders in place was a problem. And I would explain why. In the Constitution, there is a line of succession provided that if the president is not there, the deputy president will come into office, would act in that period of vacancy. If the two of them are absent, there is a Speaker of the National Assembly. And the fact that in the ruling on conservatory orders, we did recognize the significance of this office. Therefore, it will become so important if we had legislation to even provide for such situations. What should happen? In my petition, I have only asked for 2 reliefs: a finding on the unconstitutionality of the process, and on the issue and the question of a lack of legislation, which as I submit before this court and ask this court to align with your colleagues in the BBI judgment, that lack can render this kind of a process flawed. I so submit to your lordships and my lady.
Thank you.
My lords and my ladies, I see it is around 5:50. I'd requested court for 20 minutes, but based on what has been submitted, I'll only take 10 minutes because I wish not to repeat and regurgitate what my seniors and the petitioners who have come before me have already told this court. Your Honor,
I don't think we'll be able to hear you now because there's another petition we are mentioning and time is well spent. Just give us a few minutes, we'll give you directions.
Much obliged.
So I think our time is well spent. We have to adjourn to the next hearing date, which is 7th of May. We'll proceed with the petitioners' counsel who have not submitted, and thereafter we will proceed with the respondents on 7th of May. Should I suggest that we start at 9? Yes, 7th of May at 9. So with that, I think, yes?
No, I was waiting for my lord to finish giving the directions.
Yes. Yes, I've finished. We'll adjourn until 7th of May at 9. By that time, I think we'll have the services of the ceremonial hall.
My lords, your leadership, the court will recollect that when we last appeared before this noble court on the 24th of February 2025, I stated to this noble court on record, on behalf of His Excellency regarding GACHAGUA, that he was abandoning his prayer for reinstatement as Deputy President of the Republic of Kenya. To that end, His Excellency Rigathi Gachagua amended and served his re-amended petition dated 13th of August 2025, in which further re-amended petition, he abandoned the prayer for reinstatement. I wish again, my Lord, your leadership, to reiterate that position on record. My Lords, the prayers of the first petitioner are set out in prayers A to R in the said further amended petition, which, as I have said, is dated 13th of August 2025. The core of those prayers can be summarized as follows. One, the question, if this court agrees with our submissions, the question of the unconstitutional impeachment. Number two, payment of the remuneration he would have otherwise earned, plus, of course, all the benefits as per the law. Finally, for the period of 2.5 years that His Excellency Rigathi Gachagua served as the second Deputy President of the Republic of Kenya, it is our submission that Article 151 of the Constitution is fully applicable, and I invite your Lordship and your leadership to have a look at that Article 151 when you retire. Briefly, my Lord, impeachment cannot and could not have been retrospective. That is the solution. Lords, your leadership, the petitioner, first petitioner, relies on the following documents. One, his further amended petition dated 13th of August 2025, the verifying affidavit thereto, and the annexures, which are in 9 volumes, dated 18th of October 2020, of authorities and case digest, dated 7th of October, and number 3, the first petitioners written 7th October 2025, which submissions are the ones we are highlighting today before this noble court. The Lords, paragraph 1 to 19 my colleague is drawing my attention that we also relying on the first petitioner's rejoinder to submissions, which you are served rather late in the day, but the rejoinder is dated 27th of April 2026. Thank you. My Lords, your leadership, paragraph 1 to 19 of our written submissions sets out the critical background and gives context to the impeachment and the submissions we have made with regard to that impeachment. And I politely invite this Honorable Court, when it retires, to read this background in full. But permit me to briefly draw the Court's attention to only 3 matters in that background. And the first one is to emphasize the total and absolute lack of meaningful public participation. And I would draw this Honorable Court's attention to paragraph 5, which you will find at page 7 of our written submissions. My Lord, page 7 of our written submission, paragraph 5, is what I'm briefly referring to. The National Assembly conducted a public participation exercise on the 4th and 5th October 2024. However, the exercise was not adequate or meaningful. The exercise did not provide the public, for example, with the Deputy President.
Are you looking for a dream house? Or do you want to buy, sell, or rent property? Well, we can help. We can help you save money and time. All you have to do is visit www.20fast.re. We provide tailor-made solutions just for you.
For the public to be presented with what the Deputy President was saying. But that was never done. In Nairobi, for example, in the county of Nairobi, the National Assembly public participation for the county of Nairobi, capital city. The public participation at the Bomas of Kenya was presided over by select ODM members of parliament from Nairobi County, who repeatedly asserted that the event was for invited guests only. Lord, it is our submission that that is a mockery of effective public participation under the Constitution. And you'll find what I'm saying in the exhibit, my Lord, in exhibit marked RG 5 in volume 6, page 757 to 758. And also exhibit marked RG 7 in volume 6, page 764 to 765. My Lord, the second issue I would like to highlight is the rush from the word go. That the entire process was conducted by the National Assembly through to the Senate, breakneck speed, lightning speed. And the question that arises is why this speed? And our submission is that the only inference that can be drawn, and we drew, and we invite this Honorable Court to draw, is that there was a predetermined result that the National Assembly and the Senate were rushing to achieve. Technical perception that they were doing what the Constitution requires, when in fact nothing of the sort was happening. Lord, if you look at paragraph 8, 9, and 10 and 11, and they appear from page 8 of our written submission. Paragraph 8, the Lord, you see, the respondent, the third respondent, convened a session of the Senate on 8th October 2024, which then passed a resolution that the plenary would hear and consider, and I pause here to emphasize the word plenary, because both the Constitution and the standing orders of the Senate divide impeachment proceedings into stages: committee and plenary. And if the person to be impeached is to get any fair trial in the impeachment, the Senate cannot legally, constitutionally bypass the committee. It is the committee that accords an opportunity to the person to be impeached to be fully heard, not the plenary. And we will be highlighting our understanding, our interpretation of the law, that the rules of natural justice and on a correct interpretation of the relevant provisions of the Constitution and the standing order, it was not open to the Senate to bypass the committee of the Senate, where the law gives the Deputy President, the first petitioner, the opportunity before a smaller committee to fully present his evidence, be represented, and be heard. And the 10 days that later the Senate imposed itself on refer to the committee of the Senate, not to the plenary. Lord, paragraph 9, hearing before the Senate commenced a schedule on 16th of October 2024, when the Honorable Mwengi Mutuse's evidence was fully discredited in cross-examination. In this Honorable Court, you'll be taken through all that with my learned friends here. Number 10, paragraph 10, on 17th of October 2024, that was on the second day of the hearing, the Senate allocated the Deputy President 2 hours to present his case. You will see, and you will be addressed, my lords, the fact that somehow the National Assembly was allocated 3 hours. Yet, the person that was being impeached was the Deputy President, not the National Assembly. Lord, all these and many more is evidence of clear bias on the part of the National Assembly, despite on the part of the Senate, despite the Senate being presided, and I must state this, by a speaker who I personally have the highest regard for as a professional. But on the second day, and I'm looking at paragraph 10, when the Deputy President was supposed to present his case in the 2 hours that he had been allocated, he fell ill and was rushed to hospital for urgent medical attention. Rejecting the request for adjournment, the Senate voted to impeach the Deputy President on 5 out of the 11 counts. And you find all that in RG 11, volume 9, pages 1689 to 1725, response by Brigadier Gachagua. And also RG 12, volume 9, pages 1752 to 1758, communication from Nigeria. Now, the third matter I wish to very quickly draw the court's attention to in this introduction background is the absolute failure for both the National Assembly.
During my time here, I've been able to enhance my business idea through the learnings I've had about entrepreneurship and innovation. I am now much more confident into making it a scalable and viable business in the future. I'm very grateful for this experience, and I'm fully confident about what the future holds, and I'm excited to connect with more mentors and peers to make my vision and dreams come true.
The fundamental distinction between presidential systems of government and parliamentary systems of government. In a parliamentary system of government, members of parliament are entitled and have the right to kick the prime minister out of office simply by passing a no confidence resolution. No one can question the members of parliament why they had lost confidence in the prime minister. There are many examples of parliamentary system. England is a parliamentary system. India is a parliamentary system. And in fact, although in South Africa they call their CEO president, it's actually a parliamentary system because the president of South Africa is elected not by a plurality of votes, but by votes, a majority of votes. So that distinction is important. The people of Kenya decided in August 2010 that they wanted to give unto themselves a pure presidential system. Therefore, it is not the case under our Constitution that members of the National Assembly can vote and christen their resolution that there are breaches of the Constitution, and you will be addressing this fully, when in truth what they were doing was simply to say we have the numbers, passing a vote of no confidence, not violation of the Constitution. That is not what is permitted in our Constitution. And my Lord, if you look at paragraph 1 of our written submission, this is important. An impeachment is an important remedy, but one of last resort. In other words, there must be no other way of dealing with the person being impeached. One of last resort. Let me pause here to emphasize, in the National Cohesion Act, currently headed by my friend Reverend Court, one of the charges leveled against the first deputy, the first petition, was making utterances that, strictly speaking, should have been reported to the National Integration Commission. If impeachment is a last resort, why was the deputy president being rushed to impeachment on matters in respect of which he could have been taken to that National Coalition Commission and even prosecuted? That was not respecting the important dictate in presidential system that impeachment is the last resort. It is one to be used where there is an injury to the people. Why is that? Because in a presidential system, it is the people themselves, through a plurality of their votes, who elect both the president and the deputy president. The remedy should be limited to only the gravest political wrong. This is because the person to be removed from office came to that office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. And Lord, what I am highlighting here is what the court says in the song called Moving Gideon Kyoko, and another was of Nairobi City Council. So this is the judicial interpretation that is being accorded in respect of presidential system. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. There should therefore be a clear nexus between the alleged wrongs with the public trust bestowed on the governor, in this case the deputy president. It is incumbent upon the High Court, and this is important, it is incumbent upon the High Court to determine if the facts in support of the charges against the deputy president meet and prove the threshold in Article 181 of the Constitution, which is why we are before this honorable court. It is, my Lord, as I said, the first time that the first petitioner has the opportunity to state his case and to point out the lack of that high standard of gross violation of the Constitution or other written law that the Constitution prescribes. My Lord, let me now, that was a few words about the introduction. Let me now go to the issues that I need to highlight. My Lord, if you go to page 11 of our written submissions, you will see 8 issues we have drafted arising from the first petitioner's petition and our written submissions as the issues we suggest that this honorable court should address in determining this issue. My Lord, those 8 issues are the ones we have divided amongst ourselves as council, appearing for the deputy president to be addressed by each one of us. My Lord, we will avoid as much as possible not to be repetitive, but there will be different dimensions to each of the issues.
The orange car breezes and zooms on its way. A spinning spiral sun starts the happy day. Cheering trees wave and the fish jump high. The winking sun glows in the sky.
Participation. And the second one is C, whether the Senate, misled by its interpretation of Article 145, rushed the process and denied the Deputy President a fair hearing. And it is our submission, very critical submission, as we shall be seeking to do here, that the Deputy President was denied a fair hearing. And a fair hearing is cardinal in our administration of justice from time immemorial, even prior to the 2010 Constitution. And the third one is whether the overnight clearances for the replacement Deputy President evidenced a predetermined process compounded by the violations. Whether that was unconstitutional. My Lord, your leadership, the motion by the National Assembly was defective and failed to meet the constitutional threshold. First, the allegations and evidence in the impeachment motion at the National Assembly simply did not meet the constitutional threshold of Article 145(1). And you will find that in Exhibit RG1, Volume 1, page 2 to 41, the notice of motion. My Lord, in Martin, Nyaga, Wambora, and 3 others, the Court of Appeal held that the facts that prove gross violation must be proved before the relevant constitutional order. My Lord, your leadership, my learned friend Dave Wanjiru here, and myself had the privilege of arguing the Wambora case. It is a high standard in presidential systems. Not each, and you'll find that in the Wambora case, our Battle of Authorities, paragraph 45, pages 45 to 46. Not each violation of the Constitution amounts to gross violation. No, the drafters of the Constitution could have said violation of the Constitution, or other, they didn't. The word gross must carry the true intention of the drafters of our Constitution. This is the Court of Appeal in the Wambora case saying not every violation amounts to a gross violation. The charge must expressly state that the alleged violation is gross and give particulars of the alleged gross violation. Whatever is alleged against the governor, in this case deputy governor, may I say, not just the deputy governor, the law that this court will be laid down or reiterate will apply to the impeachment of the president himself. is very weighty issue that this court is asked to confront. Whatever is alleged must be serious, substantial, and weighty. There must be a nexus between the person to be impeached and the alleged gross violation of the Constitution or any other written law. The charges framed against the governor or deputy president of the country and the particulars thereof must disclose a gross violation of the Constitution or any other written law. D, the charges as framed must state with a degree of precision the article or articles, even sub-articles of the Constitution or the provisions of any other written law that have been allegedly been grossly violated. Here, my lords, in the case before this honorable court, the allegations were vague, lacking in detail, and wholly unfounded. Besides, the National Assembly erred in failing to apply the threshold and standard of proof applicable to impeachment proceedings, thus violating Article 145. For example, although the court in the Robert Alive as an Attorney General case, which is reported in 2017, 6090, nullified Section 132 of the Penal Code. The court nullified Section 132 of the Penal Code. 5 years before the Deputy President's election to office, ground 8 of the impeachment motion alleged that the Deputy President had violated that nullified law warranting his removal from office by impeaching the Deputy President on the basis of a section that had been nullified by this court. What he didn't know was the National Assembly sending to the public who had elected the Deputy President with over 71 million votes. This is demonstrative of the casualness of the National Assembly in performing a very important duty imposed by the Constitution of impeachment. My Lord, you find that authority, paragraph 62, allied case, pages 62 to 63. And although Article 145(1)(b) only applies where there are serious reasons for believing that the Deputy President has committed a crime, in ground 8, the National Assembly resolved to impeach the Deputy President for, among others, violations of a nullified law. The National Assembly then informed the Speaker of the Senate of that resolution, finding that the charge of violating a repealed law had been substantiated.
Hello?
Uncle Mo?
Yes?
This is Absa. We have a new date for the 7 Hills Run. It is 17th May, and we have concluded you will be our MC, but on one condition. You must run.
Can I run like on Teams?
No.
No,
We're
because I
looking
can't start
forward.
Teams.
Do you have some glucose? 2 sacks.
Himself by publicly criticizing a public security. My Lord, what offense was the National Assembly stating here? What article of the Constitution was the National Assembly stating had been violated by the first petitioner criticizing the NIS director? My Lord, you will see from Article 239 and in fact the NIS Act that the NIS under the Constitution 239 sub-article 5 is supposed to be under civilian oversight authority. And the Act itself clearly recognizes that, which is why you will find in the NIS Act, it is 206 of the laws of Kenya. You will find in Part 3, Civilian Authorities, the heading, Effective Civilian Authority. They then say that the Cabinet Secretary will be the civilian authority oversight. The Cabinet Secretary is part of the executive. That is not civilian oversight. Simply put, this National Intelligence Act has never complied with the provisions of the Constitution. Had they operationalized that and set up a civilian oversight authority, it is that civilian oversight authority that will take up these issues. But criticism, despite the freedom of thought and expression in our Constitution, the first petitioner was still convicted for criticizing the NIS director. So, my Lord, Your Leadership, what you are submitting here is that there was absolutely no attempt by the National Assembly, by the Senate, to address their minds to the high standard of gross violation of the Constitution. My Lord, Ground 5 accused the Deputy President of grossly violating Article 3(1) and 148(5)(d) of the Constitution and of failing to uphold his oath of office and allegiance. There were no details provided. Instead, Ground 5 simply referenced Ground 1, 2, 3, and 4. This unfair and confusing charge was such that even though the Senate cleared the Deputy President of Ground 2 and 3, it still voted to impeach him based on Ground 5. There was no attempt to explain, even vaguely, how the Deputy President had violated his oath of office. Ground 6 equally alleged that there were serious reasons to believe that Brigadier GACHAGUA had committed crimes under Section 13(1)(a) and 62 of the National Cohesion and Integration Act. As I mentioned, my Lord, and I now put this on record, why wasn't he taken fast to the national cohesion for prosecution before invoking the last resort remedy of impeachment. Because the Deputy President filed a response to the motion before the National Assembly on 8 October 2024 and was granted 2 hours to orally present his rebuttal on the floor of the National Assembly from 5 p.m. to 7 p.m. In the presentation, the petitioner made a cogent, irrefutable, factual, and legal response to each of the 11 grounds cited in the impeachment motion. Lord, you see that in Exhibit RG2, Volume 2, pages 211 to 240. For instance, concerning the claim in Ground 8 that the Deputy President had acquired property and wealth estimated at 5.2 billion Kenya shillings from proceeds of corruption and money laundering, the Deputy President explained that no valuation had been done, so where the National Assembly, Honorable Wengi Mutuse, got 5.2 billion is anybody's guess. If you want to charge somebody, you present evidence that this is the value of this property. Further, from his brother's will, the bulk of those properties to which the sum of 5.2 billion was erroneously and maliciously attached belonged to his late brother, the late Honorable James Derito GACHAGUA. May his soul rest in eternal peace. Some, like the Olive Garden Hotel, Vipingo Beach Resort, Queensgate Serviced Apartment, he did not even own. And yet, this was what he was impeached on. But we are falsely attributed to him. He produced ownership document showing otherwise, and you will find that, my lord, in RG2, Volume 2, pages 211 to 214. Lords, although the mover of the motion listed that the 2 companies associating them with the petitioner, first petitioner, alleging that they had been used to massively launder money and conceal proceeds of crime, of corruption.
Elevate your career with the London School of Business and Finance. We offer a global MBA with 5 specializations, a Master's in Finance and Investment, and a Master of Science Strategic Marketing. LSBF is a trusted institution with a 4.8-star rating on Trustpilot and a vibrant network of students originating from 150+ countries. Learning is tailored to your schedule, and all programs are available 100% online. Choose LSBF, where education goes beyond borders. Find out more at lsbf.org.uk.
A good professional colleague, who I respect, did not direct the members to the threshold test, the appropriate standard. Hence, the resolution was passed in proceedings conducted as a vote of no confidence rather than a critical step in impeachment proceedings to alter the sovereign will of the people. And you will find that as message of the Senate, number 025 of 2024, approval of special motion, RG3, Volume 6, 745 to 745. Equally, the National Assembly's decision of 8 October 2024 was invalid on the grounds that One, the impeachment motion was replete with the general unsupported allegations, hearsay, and outright lies, and lacked particularization and specificity required by Article 145(1) of the Constitution of Kenya and Standing Order 64(1)(a) of the Standing Orders of the National Assembly. 2, members of Parliament debated and voted on the motions on grounds other than those set out in the motion. The impeachment was converted into a vicarious assault on family rather than investigation of constitutional violations by a public servant. Members of Parliament, let me skip that and go through the next one. The entire impeachment process was designed to avoid and be ring-fenced from scrutiny and accountability, pushed through with uncharacteristic speed, with the intention of ramming the process through before it could be audited for constitutional compliance. The National Assembly prosecuted proceedings on the basis that the petitioner offended the president rather than the Constitution. What the 2010 Constitution provides is violation of the Constitution. In other words, the president must take time and choose his deputy. My Lord, I don't need to take time to go through what the country was put through between His Excellency Daniel Toroitich Arap Moi and his Vice President George Saitoti dangling the Vice Presidency, requiring the President to choose his or her deputy before the election so that the people could themselves vote is a very important aspect of our Constitution. The National Assembly trivialized the gross misconduct standard set out by the Constitution and other statutes for holding public servants to account. And, my Lord, I will not repeat the Wambora case, but I would state the impeachment motion was replete with generalized statements and supported allegations, hearsay, outright lies, lack of particularization and specificity as required by Article 145. My Lord, the exposition on all that is set out in paragraph 36 of our written submissions, and I will not take the time of this court going through them. I invite the court to read through it when you retire. Despite these glaring and fatal flaws apparent on the face of the motion, even on a cursory review, soon after the impeachment motion was tabled in the National Assembly, the first respondent issued a communication from the chair, number 46 of 2024, in which at paragraph 16, 18, and 20, he stated that he was satisfied that all the grounds in the impeachment motion met the requirements of the threshold under the Wambora case. The first respondent legally incorrect decision to allow the motion to proceed for debate, despite its clear failure to meet the specific and accuracy requirements of the standing orders, seems to have been motivated by Parliament's biased and reckless haste to pass the motion as quickly as possible in order to shield the process and its obvious serious rules from judicial review. It is our submission that that was the real reason for the rush. My lords, Article 50, Sub-Article 2B of the Constitution states that every accused person has the right to a fair trial, which includes the right to be informed of the charge with sufficient detail to answer, to be informed in advance of the evidence the prosecution intends to rely on, and to have reasonable access to that evidence. The motion thus violated Article 50, Sub-Article 2B, and Article 50, Sub-Article 2J of the Constitution by setting out vague allegations, criminal conduct, including the Deputy President had violated and repealed sections of the penal code, the leadership and integrity without ever charging it. Overall, the impeachment motion of the first respondent's communication from the chair was thus incapable of invoking the National Assembly's mandate under Article 150 as read with Article 145. In other words, you will see all that in RG 1, Volume 1, pages 2 to 41, and RG 8, Volume 7, page 969 to 976. So, my lord, that is all I wish to say about A. Let me very quickly move to C. My lord, issue C is there a problem with your gadget? Say hold on. I'm listening to the My lord, issue C is whether the Senate.
I need to remind you about time.
Only another 10 to 15 minutes.
You have barely 5 minutes.
Yes. Moving as quickly as I can. See, my lord, which you find at page 40 of our submission, is whether the Senate misled by its misinterpretation of Article 145, rushed the Senate, my lord, recognizes the right to a fair hearing in considering a petition for removal of a person from office, because they say so in their standing order number 81, the right to appear before the committee, the relevant committee. That is in standing order number 81. Whenever the Constitution or any other written law require the Senate to consider a petition or a proposal for the removal of a person from office, the person shall, and the word used in standing order number 81 is that the person shall be entitled to appear before the relevant committee of office. The petitioner here was denied that opportunity to appear before the committee. And the importance of the committee, my lord, is that the committee has got less members. The law gives the subcommittee 10 days to investigate. And therefore, the Deputy President would have been able to appear before that subcommittee with his evidence, with his lawyers, and would have been able to argue his case. By bypassing the setting up of that committee and assuming that the 10 days related to the plenary, which they did not, the Deputy President was denied a fair trial. Lord, when the Deputy President had all along appeared in person and signaled his willingness to take the stand, he became mute. And all of us are human beings. Lord, illness does not come knocking. One is just taken ill. And he was taken ill after very stressful, strenuous proceedings, National Assembly, and the first day in the Senate. Lord, it's a very stressful situation for the Deputy President to be deprived of that position to which he had been elected by over 7 million people. Lord, when counsel for the Deputy President stated that he had been taken ill, the Speaker ruled for the Senate, I said we were going to execute with military precision owing to the fact that we need to conclude business today. And he said I had indicated that I could not get hold of the client or the doctor's advice because he had been admitted to ICU. First, the 10 days did not apply to the Senate. That was a misreading of the Constitution in the law. But secondly, there was time we were requesting adjournment up to Tuesday to see about the Deputy President improvement. But the Speaker said they could only adjourn up to Saturday. His proposal for adjournment to Saturday was shut down by the senators voting and saying they would not allow adjournment even to the following. And no reasons were given for rejection of an adjournment to the following day, Sunday. Lord, this was a serious violation of the rules of natural justice. Lord, adjournment by the Senate is discretionary, but like all discretionary power, the discretion is to be exercised objectively, judiciously, and upon reason, not arbitrarily, capriciously, or on whims. Here, falling ill on the second day of a grueling 2-day hearing, the Deputy President sought a 3-working day adjournment to Tuesday, 22nd October, to enable him to recover and appear for cross-examination. The Senate defeated that proposal to adjourn until Saturday to see if the Deputy President had recovered. Egged on by the National Assembly, the Senate insisted on proceeding in the Deputy President's absence. My Lord, you will see at paragraph 83 of our written submission the case of the then Major General Peter Kariuki versus Attorney General. It is number 3. It is paragraph 3, page 250 in our Bible, where the Court of Appeals said the appellant's request for a 3-working day adjournment, 3 days adjournment, to instruct counsel was denied. He had been held incommunicado without access to a lawyer for over 147 days. He had less than 10 hours in total, and in a prison setting to instruct his lawyer to prepare his defense. Overturning the court-martial decision denying the adjournment, the Court of Appeal explained, it must never be forgotten that the right to an adjournment to enable a party to adequately prepare his or her case in a criminal trial is underpinned by no less an instrument than the Constitution. The authorities cited above relate to exercise of discretion to grant or refuse an adjournment in a civil dispute. We are of the opinion that although the same principles are relevant in respect of application for adjournment of criminal trials, nevertheless, because of the constitutional basis of that right, the potential impact on a citizen's liberty, the court is obliged to be more circumspect in rejecting an application for the adjournment and to specifically consider whether denial of such a right guaranteed by the Constitution would result in miscarriage of justice. And there are very many cases cited, even in the common law. My Lord, again, I had the privilege of arguing this case before the court-martial back in 1983, following the attempted coup, and also through the High Court, through the Court of Appeal. The conviction by the court-martial was quashed on the basis that Major General Kariuki, the commander of the Air Force, had been denied a fair trial. My Lord, in the interest of time, I was going to highlight the speed with which the whole process from the word go all the way through was done, but including the rest of it. But I invite the court to read our written submission. I only mention that after hearing the Deputy President on the 8th of March, finishing at about 8 p.m. Anyway, on the date that the National Assembly considered this motion, they voted to impeach close to 9 p.m. The normal working hours are daylight hours. How is it that the National Assembly has made their resolution to the Senate? Lord, it was transmitted at night. And the following day, the Senate set the date to commence the procedures. Equally, when the Senate, after depriving the Deputy President fair opportunity to defend himself, impeached on 5 out of 11 grounds. Equally, they had to transmit the impeachment resolution back to the Senate close to midnight on the same night. My Lord, I'm inviting this court to see this breakneck speed. Somehow, the Speaker of the National Assembly had in advance issued a notice convening a sitting of the National Assembly. On a Friday, which is not a normal sitting day. any thinking person will wonder how the Speaker of the National Assembly, a good friend of mine, senior counsel, how was he able to understand it? Although the resolution of the Senate was being transmitted back to the National Assembly after midnight, between midnight and the following day, His Excellency the President had a time during the night to get clearance for the person he wanted as his Deputy President from the ethics and anti-KRA. These are public institutions. In fact, the Electoral Commission did not even have commissioners to make a decision clearing the choice of the Deputy President. But I mention this to demonstrate the unholy rush. I invite this court to see through the smoke screen, cotton thrown about by the National Assembly and the Senate to confuse issues. They were mere. There was no attempt to address serious violation of the Constitution. Lord, I hand over to Rangi.
Thank you, my lords and my lady. My name is Elisha Ongoya. Number one, I have reflected on a number of unjust trials in human history. The trial of Sir Thomas More, the trial of Socrates, and even the trial of Jesus Christ. One element characterizes these trials. When you read history, there are trials that are carried out with predetermined outcomes. Those who are taken through the trials are taken through the motions for the sake of it. My learned friend, Mr. Wachira Maina, whom I've had the chance to work with, reminds me all the time that behind every constitution lies a moral idea and a moral expectation that there will be good faith compliance with the commands of that constitution. In fact, Mr. Wachira Maina informs me, and I believe him, that in management theory, there is a concept described as malicious compliance. It informs me that there is a legitimacy gap that is wider than the Pacific Ocean between good faith compliance and malicious compliance. That the first petitioner was taken through at the National Assembly and the Senate of Kenya passed the test of malicious compliance. The danger of allowing malicious compliance to go unredressed is that it injects an irredeemable legitimacy gap The second inspiration that I wish my lords to bear in mind as you determine this matter was set out by the Court of Appeal of Wambora and 3 others versus the Speaker of the Senate and 6 others. This matter traversed our entire superior court system. I'll have a very emphatic of which particular court I'm referring to when I refer to the Wambora case. So I'm looking at the Court of Appeal 2014. In that matter, the Court of Appeal began by setting out what would inspire it. And paragraph 3, case at the Court of Appeal, the Court of Appeal observes, and I quote, no parliament, no official, and no institution is immune from judicial scrutiny. I say this because to such other debt as we shall defer us to, some people will take this stand and tell you that there are political issues here that are immune from your scrutiny. The second inspiration that the Court of Appeal set out in the Wambora case, not parliament, not the executive, not the judiciary, which is supreme. It is the Constitution. I stand here to canvass one substantive question, a continuation of the threshold concerns surrounding the motion, particularly as eventually approved by the Senate. Your brother, Mr. Justice Bahati Mwamuye, has observed in the now famous Kawira Mwangaza case, law or allowing it to become a facade that masks hidden political interests runs the risk of Kenyans losing confidence in the process. That's the big risk that our constitutional order is subjected to if we allow what happened in this country, culminating into the resolution of the 17th of October 2024, to stand. It's a threat to confidence in our constitutional democracy itself. Allow me just to reiterate one question that has bothered me, and my learned senior colleague, Senior Counsel Paul Mwita, has touched on it. On 17th of October 2024, when you go through the Hansards of the Senate that I will draw your attention to in a short while, the Speaker of the Senate delivered a communication from the chair, an actual ruling, which informed the members that the first petitioner was in fact indisposed and not available to be heard as guaranteed by law. My lords will agree with me, it requires extremely compelling reasons to insist on proceeding with a case where the subject of that trial is indisposed. It must be exceptionally compelling reasons, not just reasons. When you deliver this judgment, because this matter, I've had the misfortune of sitting on the front benches of this case from the time this matter of the National Assembly to the present. This question has disturbed me as a role player in the justice, law and order sector. That the Senate of Kenya, even after the Speaker erroneously, and I use the word erroneously, advisedly, because my learned colleague, Mr. Dudley, will take you through the timelines for impeachment in Article 145, as read that one proposition. But even after the Speaker erroneously said, we have a timeline of Saturday. They had no such timeline, but the Speaker said so. The senators voted to deny the Deputy President the benefit of those 2 or 3 more days without giving any reason. I would want to read in your judgments, my lord and my lady, through what logic this court will allow that decision to stand, if no other decision, that particular one. That for no reason, we are not saying the heavens will come down falling. We are not saying the country will be subject to any external attack. We are not saying there is any constitutional imperative that compels us to do it tonight. No reason. They simply said, we will not give him the benefit of those 2 days that the Speaker has said we still have. Let's go on record. The Speaker too was wrong. But there may have been some veneer of good faith. If they had said it's okay, because we have 2 days, let's give him the 2 days for whatever it is worth. They said, even that, we are not going to give it to him. Tasked to bring to your lordship's, ladyship's attention are the following. Number 1, Article 150 Clause 1 of the Constitution sets out the constitutional textual threshold for removal of a deputy president from office by impeachment. And it says, is on the grounds of gross violation of a provision of the Constitution or any other laws. Secondly, it says is on the ground of serious reasons to believe that the deputy president has committed a crime under national or international law. Serious reasons. I'll be making out a simple case that the National Assembly really disappointed the country. To approve a motion that there are serious reasons to believe that the deputy president has violated a provision of the law, Section 132 of the Penal Code, which has been declared unconstitutional, null and void, is a locus classicus of lack of seriousness in the reasons. And thirdly, the standard of gross misconduct. Let's face it, my lords, my lady. The drafters of this constitution could as well characterize these wrongs as violation of the Constitution, because that's also a wrong, or reason to believe that the DP has committed a crime, or misconduct. Those are wrongs. But they were particular to add these descriptive words, gross, to the violation, gross to the misconduct, and serious to the reasons. The conclusion I draw from this is that they set a very high threshold for removal of a deputy president from office. Our courts have followed cue. I will start with the Supreme Court, sample 2 decisions there. Go to the Court of Appeal, sample 1 decision there. Then go to the High Court and sample 1 decision there. From the Supreme Court, the decision of Sonko versus the County Assembly of Nairobi City and 11 others. Yes, yes, we do. Yes, we do. Correct, correct. Okay, okay. I'm highlighting, my lord, so I was avoiding reading them. So I'm drawing simply because if I have to take you through the pages, then it means I have to actually take you through the submission themselves. I'm just highlighting salient aspects of those submissions so that we save on time. Thank you. So that in Sonko versus the County Assembly of Nairobi City, I beseech this court to look at paragraph 161 of that judgment. The Supreme Court observed that the grounds for impeachment and removal from the office must be substantiated. The grounds for impeachment and removal from office must be substantiated. It means, my lords and my lady, the motion mover and his supporting cast of witnesses must show us where is the supporting evidence for each of those grounds. They must show where the supporting evidence is. Because substantiation simply means adduction of adequate evidence to lend credence to the ground. The Supreme Court then sets the standard as what has now been called the intermediate standard. Not so low as to be on a balance of probabilities, and not so high as to be beyond reasonable doubt. You will find these descriptive words of grounds for removal from office in removal of other office bearers from office under our constitution, like judges of superior courts. They'll be removed on similar grounds. And you'll see the Supreme Court has dealt with that in the case of Muya versus the tribunal appointed to investigate the conduct of Justice Martin Mati Muya, Judge of the High Court. In that matter, the Supreme Court now attempts to give us the meaning of the word gross. And you'll find that at paragraph 181 of that judgment of the Supreme Court. And it says, and I quote, clearly, all the words used to describe gross express some extreme negative conduct. Not just negative conduct. It says extreme negative conduct. Then it proceeds to say a degree of misconduct of such a serious, outrageous, and flagrant nature that would warrant removal of a judge from office. That is how serious it ought to be. Those are the words of the Supreme Court. So, the Court of Appeal, I have already observed, sets that standard in the Martin Nyaga Wambora and 3 others. I'll just refer you to paragraphs 42 through 45 of that judgment. But there is something else that I want us to draw from the Martin Nyaga Wambora case. How to frame charges for an impeachment motion. Because the Court of Appeal also dealt with that question. And when you look at paragraph 44 of the Martin Nyaga Wambora decision, the 2014 Court of Appeal decision, that's one I have in mind. If you look at paragraph 44, you will see that the Court of Appeal draws similarities in drawing charges for an impeachment motion to drawing criminal trial charges for court. In fact, the court uses an example of how to draw a charge of robbery with violence in trying to explain how specific a charge for impeachment should be. I say this because in drawing criminal trial charges, there is a wrong in framing charges called multiplicity of charges, and I'll show you how that wrong applied in the trial of His Excellency Rigathi Gachagua. Then finally, for the High Court jurisprudence, I will refer you to the High Court decision in Honorable Mike Sonko Mbuvi, Gideon, and Okia Omtata versus the Clerk, Nairobi City County Assembly. These were two consolidated petitions. And I will draw your attention to paragraphs 257 through 259 of that judgment of the High Court. For ease of reference, I will refer you to the various aspects of the impeachment motion that is in volume number 1 of the petitioner's document from pages 1 to 209. Look at that volume. And I'll refer you to the Hansard proceedings of the Senate. You'll find the Hansard proceedings of the Senate in the documents filed by Mukele Moni advocates in the CTS that are labeled Parts 5 and Part 6. Part 5 and Part 6. In Part 5, you'll find the Hansard of 16th October 2024. Then in Part 6, you will find a continuation of the Hansard of 16th October 2024 and the Hansard of 17th October 2024. That Hansard is also referred to in the affidavit of my very good friend Jeremiah Nyegenye as Annexure JN 10 at paragraph 31 of that affidavit, which was sworn on 21st October 2024. So, returning to the question under scrutiny from my end, I will invite you to look at page 59 of the Hansard of 16th October 2024. This is now the page of the Hansard itself, not the page of the bundle, because my learned colleague, Mr. Mukele, did not paginate the full bundle. So you look at the page of the Hansard itself. Something very interesting happened. I want to paint the picture so that I abridge on time. Before the trial of His Excellency Rigathi Gachagua at the Senate issued a trial schedule, a schedule of the proceedings. The National Assembly had given the Senate a list of 5 witnesses. His Excellency, the Deputy President, had submitted his affidavit alone as his own witness. So the DP side had 1 witness, being the DP only. The National Assembly presented 5 witnesses. When the schedule came, the schedule gave the DP's team 2 hours to cross-examine the 5 witnesses of the National Assembly and 3 hours to lead the evidence in chief of the Deputy President. The Deputy President's team took the view that it did not need 3 hours to take their witness in exam in chief. This is their own case. they suggested to the Speaker that we need these 3 hours for our exam in chief, and perhaps the 3 hours for our cross-examination of the National Assembly witnesses, and perhaps the 2 hours for our exam in chief. So we are not taking any more time of the Senate. We're just reordering our own time, the one you have given us. At page 59 of the Hansard of 16th October 2024, the Speaker dismissed that literally by wave of the hand. I mentioned three significant trials that have shown me that when these kind of things happen, it means there is malicious compliance. We are simply going through the motions. No one is asking for the Senate any more time. We're just saying of the time you have allocated us, we have a lot more duty in cross-examination. Give us more time towards that. We have lesser duty in exam in chief. From our own time, give us less time on that. It is judicially noticeable that the Speaker of the Senate is a lawyer of many years standing. It cannot be that he didn't understand the injustice inherent in the disproportionality in that time allocation. It cannot be he didn't understand. He understood it by virtue of the trust bestowed upon him as a trained lawyer. He breached that trust. Allow me to then very briefly take you through the various grounds of impeachment as set out in the motion and the evidence, what the evidence revealed in respect of each of those grounds. I would start with the ground number 4 of the impeachment motion. The particulars of that ground will be found at paragraph 34 of the motion itself. The particulars of ground number 4 will be found at paragraph 34 of the impeachment motion. This is one of the grounds that the Senate approved and which contributed to the loss of office of His Excellency Rigathi Gachagua. The particulars state that the Deputy President made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court of Kenya, and falsely threatened to file a petition against the said judge in gross violation of Article 160, Clause 5 of the Constitution. It is a requirement in impeachment proceedings that the impeaching house cannot introduce any new grounds at the Senate stage. They are held to account on the grounds as approved by the National Assembly. The ground was that the Deputy President made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court, and falsely threatened to file a petition against the said judge in gross violation of Article 160, Clause 5 of the Constitution. So a number of things are important, my lords, my lady. One, what does Article 160, Clause 5 of the Constitution provide? It provides that a member of the judiciary is not liable in an action or suit in respect of anything done or omitted to be done in good faith in the lawful performance of a judicial function. It's not liable in suit. You can't take them to court. If you look at ground number 4 and particulars of paragraph 34, it is alleging that the threat to take a judge to the Judicial Service Commission is a violation of Article 160, Clause 5. I wonder, their lawyers are here, they will tell us, In fact, some senators are actually here. They will tell us, how does Senate read Article 160 Clause 5 as against Article 168 Clause 2? Because Article 168 Clause 2 constitutionally gives any person the right to initiate a petition before the Judicial Service Commission for the removal of a judge. So if you state that you are going to pursue an Article 168 Clause 2 process, how can that be a violation of Article 160 Clause 5? I was taught many years ago, I hope it's still learning today, the Constitution is not self-annihilating. We cannot read Article 160 Clause 5 to destroy Article 168 Clause 2. So that the National Assembly brought a case to the Senate that a claim by the Deputy President that he is going to file a petition against Justice Esther Maina is a violation of Article 160 Clause 5. The Senate approved that ground for removal of the Deputy President. Now, let's not lose focus of this, my lords. The express text of the ground and the particulars at paragraph 34 of the motion is that the Deputy President had falsely threatened to file a petition against Justice Maina. Now, the Supreme Court has told us the ground must be substantiated. So I will now take you how the motion mover substantiated the ground. If you look at page 60 of the Hansard of 16th October 2024, it's on the attached to the affidavit of Jeremiah Nyegenye as Annex JN10. The following conversation takes place. The motion mover is being cross-examined by yours truly. The Hansard of the Senate captures me as asking this question. Do you still stand by that part of your allegation that he has not presented the complaint to the Judicial Service Commission as at that date? The motion mover says, I have since learned that he did present the petition. The motion mover is conceding that his claim in the motion that the Deputy President falsely threatened to file the petition cannot pass muster. Yours truly, my lords, then suggests to him that to the extent that you say that he has not presented the allegation to the JSC as at 26th September 2024, that allegation is not true. Is it? The motion mover says, we are in agreement, counsel. The motion mover concedes that the ground on which his motion is founded, ground 4,
Mbozana tuli mbozana I will sing Hosanna. Hallelujah, I will sing Hosanna. Abalungi abaagalwa nsanyusa okubalaba mu nnya lya Mukama waffe Yesu, mbaniriza nnyo akawungeezi ka leero. Nsaba muwulire emirembe ku ASPRC muwulire Bible and Politics. Ntuuseemu koleeti katono. Kale tugenda kuba tudduka emisinde mu bintu bingi nnyo. Tulina ebintu bingi nnyo bye tugenda okuba nga twogerako akawungeezi ak'olwaleero. Nsaba owulira emirembe ku Bible and Politics. Tugenda kuba twogera ku bintu bingi nnyo. Mmanyi Mukama ajja kuwayo ekigambo eky'amagezi n'okutegeera oba ekigambo eky'obulamu ekisobola okukuyisa maybe awo awabadde wakuzitooyeredde. Ebimu tebyetaaga ssente, ebimu tebyetaaga, just weetaagayo ekigambo kya Katonda, weetaagayo ekigambo kimu kisumulula ebintu byonna bitandika okwetegulula, ove ku ddaala erimu ogende ku ddaala eddala. Omusajja yagamba Yesu nti nedda gwe yogera bwogezi kigambo, omwoyo gwange gunaawona. Olwaleero z'ennaku z'omwezi 28 omwezi ogwokuna omwaka gwa 2020 leero ziri 27 leero ziri 27 mu kusaaga leero 27 nga nziruka emisinde mingi. Olwaleero ennaku z'omwezi 27 omwezi ogwokuna omwaka gwa 2020 ebadde ki? Ennaku z'omwezi nga nazisobezza nziruka ki? Leero ziri 27 wamma 27 Puroguramu eno ey'ekiro kirabika yenkyankalanya mu nnaku z'omwezi kuba ebeera mu makkati g'ennaku 2 yendeetera obuzibu eyo puroguramu ya gundi ettundi mu kiro. Okay, kale nsaba owulira emirembe mu kifo kino. Olwaleero ngenda kwogera ku kigambo, ngenda kwogera omutwe gw'obubaka bw'olwaleero, ngenda kwogera ne bannayuganda mwenna obutamala gakkiriza buli ekikugambibwa obutamala gakkiriza n'oggwamu essuubi n'okkiriza. Waliwo abasomesa ba Bayibuli mu kitabo kya Isaaya essuula eya 38 tutera nnyo okubuulira okuva ku lunyiriri olusooka otuuka ku lunyiriri olw'omunaana, era nakabuulirawo emirundi ng'ebiri oba esatu. Kezekiya n'alwala endwadde era awo Isaya najja n'amugamba ogenda kufa so togenda kulama n'akyukira ekisenge Mukama n'agamba Isaya genda omugambe mwongedde emyaka 15 awo ne tulyoka tukuba yirimu awo era emyaka gyeyongera era wakati Mukama akwongedde era naye waliwo ebigambo ebiri ku lunyiriri olw'omwenda okutuuka ku lwabiri mu ebbiri olwaliro byebindeese. So wandika Isaiah chapter 38 from verse 9 to verse 22. Yesembayo ebigambo ebyo byebindeese ebiri ku lunyiriri olw'omwenda okutuuka ku lwabiri mu ebbiri. Njagala tubiyite mu kigambo ku kigambo lunyiriri ku lunyiriri nga bwe tubijje wa Kezekiya nga bwe tubireeta mu bulamu bwo obw'olwaleero kuba Kezekiya tetwamulabako kati ye tugenda mwesonyiwa tugenda kumujja mu picture ye Kezekiya tusoke tumujje mu picture Uganda eddewo muna Uganda oddewo bw'ona ova wano ng'omala gakkiriza kuba bwe yali alwana n'Obote yeekweka Sweden nga gyasinziira so amanyi bulungi nnyo ti gavumenti ye amaanyi agava mu diaspora gajja giyuza yoga ku ttaka n'aleeta etteeka eddala etteeka eryo nga ligamba nti omunayuganda yenna okujja okukola kino kituli bukola okusinkana ne mwogera ku byobufuzi by'eggwanga ogwo musango gwe munayuganda okuweereza ssente ewaka maama wo taata wo sengawo musango gwe munayuganda awagira NUP oba FDC oba DP oba UPC okuweereza kubanga constitution yaffe providing for freedom of association uliwadde okubirongenga ku kibiina kyonna era bamemba b'ekibiina be bakivujjirira ffe bannayuganda ababeera eno be babaddenga batu wa ssente zetugulamu amafuta zetu abaana zibalabirira bali mu komera n'ebifaanana bwe bityo kati baagala gufuula musango nti gwe munnayuganda okwatanga $100 $100 $200 okubiweereza ekibiina kyo e Uganda gyogwo musango era osuba emyaka 2 bagezaako kwagala kutiisatiisa bagezaako okudisconnectinga bannansi era n'ekirala baagala kujjako bannansi obutuuze bwa Uganda etteeka eryo liraga nti kasita ofuluma Uganda oba tokyali munnauganda ate maama wo taata wo sengawo akolagana naawe akolagana na mugwira yet si citizen are receiving sente okuva wa relative bamuyita agent of a foreigner gwe Uganda toli munnauganda oli
With so many countries represented here, walk proudly with the passport of your faith and your words. Enjoy enjoy your time, have fun, make friends, and don't hesitate to say hi when we cross paths. Join the parties, they're very fun, the clubs, and the celebrations. Embrace your diversity and be yourself. We are cheering you on.